Good afternoon. Welcome to the annual Herbert L. Bernstein Memorial Lecture. This lecture celebrates the life and work of Professor Bernstein, who was a wonderful teacher, colleague, and scholar at Duke Law School for 17 years before he passed away in 2001. He was born in Hamburg, Germany, and during World War II, he had quite a harrowing childhood there, surviving at one point in a pigsty. He then came eventually to this country. He studied at the University of Michigan, where he got his law degree, and then he taught in various places, including Southampton, and then he came to Duke in 1984. His fields of scholarship included comparative and private international law. I didn't have the pleasure of knowing him, but there are people in the room who did know him, and he made a big impression on all who came to experience his warmth, his kindness, his commitment to justice, and his humor. It's clear that he had a profound effect on students and colleagues alike. We are honored here to welcome back to Duke Justice Daphne Barak-Erez to deliver the Bernstein Lecture. Introducing her is Professor Ralf Michaels, who's a distinguished scholar in comparative law and also was last year's Bernstein Lecturer. Ralf.
Thank you, Dean Levi. Thank you, Daphne, for coming. Your colleagues, friends, everybody else who's neither colleague nor friend. Let me welcome you and introduce our speaker this academic year, Daphne Barak-Erez. She's a judge, as you heard, at the Israeli Supreme Court, which, as you can imagine, is a busy job. And you might say we're very lucky that we have her, that she could accept our invitation. But of course, once you start looking at her CV, you realize it's impossible that there is just one Daphne Barak-Erez. And so maybe there's one that's still in Israel at the moment judging, whereas we just got another one. How many do we have and which one is here? One, Daphne Barak-Erez is a leading Israeli scholar and teacher. Daphne was for 20 years professor at Tel Aviv University, ending her position there as a dean. She taught mainly, I understand, constitutional and administrative law, also contracts and payment systems, and feminist jurisprudence, and she writes a lot. Her CV lists 20 written or edited books. That's about 20 more than most of us. More than 100 articles in Hebrew and in English. When I was in Tel Aviv for a month in June, the university celebrated a book publication by her, which I thought was a great chance and coincidence. It now occurs to me that they probably have such a book celebration every other month in Tel Aviv. And indeed, she writes across wide areas: feminist constitutionalism, the judicial review of security measures in the occupied territories, the law of historical films, private prisons, and my favorite book title of all, Outlawed Pigs. The second, Daphne Barak-Erez, is a judge indeed at the Israeli Supreme Court. She was appointed in 2012 as the youngest person ever to be appointed to the Israeli Supreme Court, and a sign, therefore, that for some people the trajectory of their careers is to be first a dean and then a judge, and not the other way around. The third Daphne Barak-Erez is an American, or at least a person with close affinities to the United States. In fact, she was born in the United States and therefore was a US citizen for a long time, until she had to give up citizenship in 2012 in order to become a judge at the Israeli Supreme Court. You cannot have citizenship, I understand, of a foreign country in order to have that position. I also understand that the officials asked her whether she was giving up her citizenship because someone had pressured her, which I guess is a complex question, but he said, no, I actually have the opportunity of becoming a judge at the highest court in Israel. I also understand the official did not see how that could be worth more than US citizenship, which maybe says something about our own country here as well. There are more Daphnes, of course. There's a Daphne who is a member of the Military Advocate General's Corps for a number of years and was a captain at the time of her discharge, which I think is a good thing. Lots others. The last Daphne I want to talk about is the friend and the good person that she is. To start with the good person, she has won tons of prizes that are basically also good person prizes, among them, what I understand, the Woman of the City Award by the city of Tel Aviv, and the Women in Law Award by the Israeli Bar. You can ask yourselves which of them counts for more or less. And she is a genuine good person. We visited in June at the Israeli Supreme Court. I brought my 3 children who always manage what many people in Israel have tried to do before, which is to bring down the entire Israeli Supreme Court. And she graciously overlooked those attempts, which were fortunately unsuccessful. She has also graciously agreed to come here, not just to give the Bernstein Lecture, but really to meet with our students, to go into one of the classes. And we're really making lots of use of that one person that is Daphne Barak-Erez, or indeed of all 4 or 5 and all of them. And so I ask you to welcome her with a 4-fold applause for being here as the Bernstein Lecture this year.
Well, hello everybody, dear guests, students, friends and colleagues. It's a great honor for me to be here and thank you for this warm welcoming. I hope to deserve it. As I said, it's a great honor for me to give the Bernstein Lecture, which I'm fully aware of how prestigious it is. And I'm also delighted to be back here at Duke for the 3rd time. I feel at home here, and I'm truly happy to be here again among friends and to meet students, which is something that I miss to a large extent since I'm on the court. My updated title of the lecture today is Battles of Reproductive Technologies and Comparative Tales of IVF. Because indeed, what I'm going to share with you is comparative tales, how different courts in the world have imagined how to think about conflicts around IVF procedures with the ideas and concepts that courts share around the world, and at the same time taking into consideration cultural differences, different histories of various systems. And I think that my lecture today will play a lot between these 2 sides of the story. The fact that there are many shared concepts and values that are relevant, and at the same time also differences in institutions and cultural histories of various systems. Another reason for me to choose this subject matter is that it brings together, on one hand, developments, extraordinary developments in medical capabilities on the one hand. So in some ways, this is a very modern, ultra-modern topic. And at the same time, it touches on the desire for parenthood, which is very traditional, very basic, very much at the center of, human, thought from very early times. So we are talking here about something that is both very new and at the same time very old, just at the same time. And what I will mostly try to show is how different institutions and metaphors are used by courts around the world to think about this new topic, because when courts are confronted with new challenges, they try to use analogies. They try to think, how does it feel like? Is it similar to another problem we were dealing with? Is it, and I will already throw a few hints, is it a contract? Is it property? Is legislation relevant? Is it about reliance? Is it about life and its importance? And we will see that the metaphor or the analogy chosen by the court is to a large extent an important factor deciding the ultimate result. Because if we decide to think about something through the metaphor of contract, we may get to a different result than if we chose a different metaphor, analogy, or legal institution to start with. So these are just a few general remarks that I'm starting with to let you know what I'm going to discuss today. And of course, now I'll try to look at these issues in more detail. And by the way, I will eventually, at the end of my lecture, will welcome a few questions as time will allow us. So, as I said, the aspiration for parenthood is considered one of the inherent traits of humankind, very prevalent, and transcends conditions and cultures. But at the same time, of course, it's also very culturally dependent. And we'll see how this plays into the legal discussion. And to what extent does it also, these differences between systems also influence the choice of the possible legal models that I already pointed at, contract, property, life, etc. I would like to add, however, a few words on the importance of comparative law in this area. After all, we are here, celebrating the importance of comparative law. And I think that recourse to comparative law seems to be especially useful with regard to legal questions touching on the use of reproductive technologies and IVF. And this is for several reasons. First, these technologies occurred in different places around the world around the same time, of course, only roughly speaking. So we are confronted here with a question that was dealt with by different legal systems around the same time, looking for solutions. And it's interesting to see where these systems were looking for these solutions. Second, some of the moral and human dilemmas are the same. So if we're talking about moral dilemmas that are the same, it is even more interesting to see how different systems were dealing with these dilemmas. At the same time, as I already mentioned, although there are some shared values and moral questions here, the analysis of the questions is also deeply influenced by the background cultural conditions. So we have here both the justification to expect similarities and at the same time expectations also to find not always quite the same answers. And in the background, we have in all systems, in different degrees, the overarching question whether what is feasible from a scientific and technological perspective should also be permissible from a legal perspective. And these are not necessarily, or necessarily, they are not the same. As I said, I believe that cultural differences here are important, are relevant, and I will try to just exemplify this argument, and I'll start by my own country of Israel. I think that Israel can be generally described as Israeli culture as a culture that is very family-oriented, where the role of family and bringing children to the world is considered very central for both reasons attached to Jewish religion, tradition, but also because of national traumas like the Holocaust. So children are considered very central and investing in bringing children to the world. I'm not saying this from a normative perspective. I'm just describing, cultural conditions. And I believe that we will see the influence of that in the way this question is being dealt with. And I can also tell you a few formal facts that Israel supports assisted fertilization in a benevolent manner, that fertilization treatments are included in Israel's national health insurance law. This is not obvious in other systems. So we have here a system that is very much invested in the issue of children in general and IVF procedures in particular. So there is a very advanced case law in this area also because of these background cultural conditions. If I think of Germany, and I will not get into details about Germany, but if we read materials on this issue in Germany, we can feel that the analysis of the matter was at least partially shaped by resistance to the country's Nazi history and experimentation, with children, abortions, etc. I'm also only saying that this is somewhere in the background. And if we think of the US, and I will touch also on US case law in my lecture, although there are better experts on US law in this room than me, but I'll use also US case law in order to bring here to the fore the comparison. So, but I will allow myself as a viewer from outside observing US law that we can see that case law, this is at least my interpretation, is influenced to a large degree by the background culture of freedom of contract, the importance of freedom of contract in American legal culture. In order to proceed now, and don't worry, I will eventually get to actual cases, but in order to analyze actual cases, it is, I think, very helpful to set and define the questions and the tools that I'm going to use and rely upon. So another distinction I would like to bring here to the room is the distinction between what I call the horizontal and the vertical, between horizontal controversies in the area of IVF and vertical controversies. These are two types of litigation that we can find in different systems. And for our purposes, it's very important to distinguish between them. I'm sure you'll soon see that this is a very basic and intuitive distinction, but I'd like to present to you this terminology. When I use the term horizontal controversy or horizontal controversies, I mean that these are controversies litigated between at least two private parties who have different aspirations regarding a parenthood project they are involved in. For example, two ex-partners who started the IVF procedure together and now have different views about how to go about, with frozen embryos, like the typical case that I will concentrate on in my lecture. But I would like to juxtapose this or distinguish this from the vertical controversies, which involve conflicts between individuals and the state, when the state or one of its agencies does not want to allow individuals to move forward with technological possibilities that may allow them to reach aspired parenthood. And this would involve questions such as, is surrogacy legal at all? Is it subject to different conditions? And I think that it's important to make this distinction because sometimes the two types of litigation become interrelated. For example, think of the possibility that two ex-partners have different visions about how to go about with a project, the IVF project that they started when they were in better terms. But on the top of that, the state in which they live does not recognize the legality of surrogacy in those cases where they also need surrogacy. So they don't only need the fertilization treatments, but also need the help of a surrogate mother. And in this case, there are two questions. I mean, whether they can resolve the conflict between themselves and whether the state, even if they get to an agreement, will allow them to go to move forward with a surrogacy process. And it is sometimes the combination between the horizontal controversy and the vertical controversy lead to, I would say, even more complex legal conflicts. By the way, we are familiar with this distinction also in the area of abortion law, because we can imagine on one hand that two partners or ex-partners will not have the same view about abortion, and at the same time there is also the issue regarding the question whether abortion is legal or is it legal only under certain conditions, and these two different spheres of controversies may sometimes also have some connection between them in order that complicates the legal controversy. Of course, there is a very basic difference. I'm raising the issue of abortion, although I'm not going to discuss it. I mean, this may serve probably a subject for a series of lectures. But what I want to say is that there is an important difference between the abortion context and the IVF context, because in the abortion context, there is also the issue of the physical integrity of the woman's body, and the IVF context, to some extent, frees us from this additional concern, because in the area of abortion law, there is like this trump card. I mean, well, it's the woman's body, so this should be given an important role. Whereas in IVF, well, at least theoretically, I'm not saying that this is like this in actuality, but at least theoretically, it's not about the woman's body, and therefore there is no additional importance to the woman's view vis-a-vis the man's view. So in this sense, also discussing IVF controversies helps us to have another perspective on questions we think about also in the area of abortion law, but in the area of abortion law, we are burdened with this overarching issue that it's the woman's body, and therefore we concentrate on that, and we don't allow ourselves maybe to see the other aspects of the controversy. So there are so many possible ways to proceed from here, because I have presented to you many aspects of the matter. And as we know, we only have one lecture, so I'll have to focus on some of these aspects. And I decided to focus on horizontal conflicts in the area of IVF. And I want to explain why I made this choice. First, IVF litigation in the horizontal arena began accumulating earlier. I mean, we have a longer history of this type of litigation, especially in the US, when IVF procedures started to be used with no legislation or, I would say, central litigation in this matter. And then conflicts emerged between ex-partners, and we have a longer history of case law in this area. So if I want to have to present to you maybe a development of thinking on this matter, so we have more to see in the area of horizontal litigation. Second, I think that in the horizontal arena, we also have to address, we are confronted with questions that make us think about the issue of parenthood. What does it mean to be a parent, and what does it mean maybe to be denied parenthood if the decision is against the promotion of the continuation of the IVF procedures? And third, and now I'm going back to the theme of the use of comparative law, I think that also we are less influenced in this area by the background differences in the constitutional design or concepts of the systems. I mean, we don't have to really study deeply the constitutional differences between the systems. I mean, when we are relatively in the area of clashes between individuals, so it's easier to see clearly because individuals are individuals all around the world. So at least this was my choice. I tried to present my reasons for this choice. What I'll do from now on is I'll try to use examples that will show how courts were searching for a model in this area. Because as I said, courts all around the world were confronted with a new question, not necessarily ruled, regulated by legislation. And the question was how to think about it. And as I mentioned in my introduction, courts decided to use institutions and analogy and legal institutions and concepts that they knew from their prior experience. This is how courts think, usually. I mean, this is one of the methods that you are also familiar with in law school. Is it similar to what? And here there are a few institutions that I already mentioned briefly, and I will now mention in more detail. First, is it contract? And we will see that most courts analyzed the controversies in this area, and again, controversies among individuals, usually ex-partners, using contract law. Why did they do that? Probably because, to some extent, it felt natural to do that. We are talking about people who were agreeing on something. So if they were agreeing on something, if they had some kind of mutual consent, so it sounds to us like a contract. So let's apply contract law. We'll soon see also the difficulties. I'm not describing how these things were developed, at least the way I see it. In addition to that, in many of these cases, even if there was no formal agreement, written agreement between the parties, there was another formal contract in the background, usually a contract with the clinic with which they contracted in order to proceed with the process. So, of course, there is a difference between the contract between the parties on one hand and the clinic on the other side, and the possible agreement among them. But once again, I think because there was also another contractual relationship with the clinic, so this gave, I think, background support to the use of contract law. I will show later that the use of contract law usually led to a preference given to a party who was not interested in moving forward with the fertilization process. Now, I think that most of the American case law that you are familiar with follows this tradition of contract, but not all of it. And the question is whether there are other models or other concepts that are worth exploring. Another model that I would like to present And I think it is an important one, although not always described in this manner or using the terminology that I will present here, is the concept of reliance. That is, whether law should protect the party who relied on the beginning of the IVF procedure in those circumstances, or maybe only in those circumstances, where not following the agreement will bring to irreversible consequences for that party. This is not always the case, but we are talking about the last chance cases for those parties for whom, if they cannot move forward with this particular frozen embryos, there is no other chance for having a chance, there is no other chance for biological parenthood. So, and I will present to you the cases. Of course, so far, I only mentioned the contribution of courts. What is the role of legislatures? This is a new challenge for society. What is the responsibility of legislatures to help individuals in society resolve these controversies and also plan their decisions accordingly? We will see that in many systems, legislatures are reluctant to legislate on that, and therefore contract law or the use of judicial methods is so popular because we don't have solutions in legislation, and therefore courts have to imagine solutions. But I will also present examples for legislative actions in these matters. For example, I will bring the UK example where legislation was in place since the early 90s. And the question is whether legislation necessarily brings to better solution. As you can imagine, it brings to better solutions only if the legislation is good. If it's not good, so I mean, we remain with the same problems, and I will show. By the way, there is another private law concept somewhere in the background, and that is property. Why think about the agreement between the parties why think about it focusing on contract law? Why not imagine the frozen embryos as property, property owned by two partners, and therefore maybe apply considerations and doctrines from property law? And indeed, there are some cases that use property law, and I will also point to some of them. But I think that if we are observing the legal arena in this area more broadly, we'll see that property does not, at least this is my observation, property does not fulfill an important role for various reasons. First, because also when people own property, they can also contract on that property. And if we believe that there is also a contract in the background, the fact that we imagine the frozen embryos as property does not lead to any independent solution, independent of the results of contract law, the contract regarding that property. Also, it's not that easy, or it may be considered problematic to think about frozen embryos as property. Not necessarily, or not only for people who believe that this is a form of life, but I think that even for people who don't think that this is life, I think that people are reluctant to use the analogy to property law in a sweeping manner because of the reluctance about commodification of human materials. Do we really want to think about human materials as mere property that are open for market decisions? And maybe for this reason, we can see in the renowned US case of Davis v. Davis, the first well-known case in this area, that the court stated that the frozen embryos are property deserving special respect. So we may, use some reference to property law, but it's not ordinary property. It's property deserving special respect. And if this is property deserving special respect, so property law as such does not give us an immediate solution, an immediate answer. By the way, I mentioned that some would think that also maybe, the pro-choice, pro-life, thoughts may be relevant here. This is not my view, but I want to present it because it's also part of the legal arena. But I think that even legal systems that are closer to think about conception as the beginning of life are reluctant to apply this view in a simplistic manner in the area of IVF, acknowledging the fact that there is still something different about the IVF context. And I want to mention here the decision of the Supreme Court of Ireland in the Roche v. Roche case, where the life argument was presented to the Irish Supreme Court, and maybe for a good reason, because in the Irish Constitution there is an express provision stating that the state acknowledges the right to life of the unborn. So the litigants could have thought that maybe this is a very good way to start, because there is an express, seemingly relevant provision here. But the Supreme Court of Ireland held, however, that when accepted, this constitutional provision did not foresee the situation of frozen embryos, and therefore this provision should not be applied in a simplistic manner in this context. And although frozen embryos should definitely be treated with respect. Again, I'm not an expert on Irish law, but I'm bringing this just to see that there is also this additional perspective, and probably not a very fruitful one. Even in Louisiana, I read that according to the legislation, a frozen embryo is regarded a person. But at the same time, this does not lead to the conclusion that therefore it should be unconditionally protected, because at the same time, the law states that questions with regard to the frozen embryo should be decided in the best interest of the in vitro fertilized ovum. So it's not treated as just as a person in the full sense of the word. So these are the various models that are in the background. Let's see now in more detail how the case law evolved in this area. As I said, I will concentrate on the evolvement of the case law in this manner using the contractual model, which used to be like the main road. And I will mention very briefly some of the more well-known American cases. And then I will show the alternative to this way of thinking, using also case law from Israel, from the UK, to see that maybe this is not the only way to think about it. And once again, this is the blessing, I think, of comparative law, that we can, learn from the experience of more than one system. As I said, and again, I feel very humbled when, I analyze here also U.S. cases, and, I'm a foreigner to U.S. law, but with all the needed hesitation, I will still allow myself to do that. So and I have to start with the U.S. Well, we are in the U.S., but in addition to that, I think many of the early cases emerged from the U.S., maybe because IVF treatments with the blessings of medical research in the U.S. just, evolved earlier. And in most of these cases, the court, not the court, different courts in different states. I mean, we're talking here about decisions of state courts. But with all the distinctions between states, we see that some basic concepts control case law in different states. And what we see that in most cases, in different states, with some nuances, but generally speaking, courts imagined the agreement or the understanding between the parties as contracts. And as I already mentioned, this choice almost necessarily led to the prioritization of the party who was not willing to move ahead with the IVF process. Why? Because if on one hand the parties decided that in case that they split, that one of them will be able to move forward with the treatment, so courts tended to decide that such a contractual provision is unenforceable because it's not proper to enforce contracts of this type that are close to the idea of servitude or something that is too personal to enforce. Or maybe it's even against public policy. There are uses of various doctrines. But if there is even an express agreement to move forward, then the contract is unenforceable. And if, on the other hand, the parties agreed that in circumstances of splitting their ways, they will, for example, donate the frozen embryos or give them to research or make them discarded in another way. So if there was such a contract, so usually the courts, and then one of the parties had a change of heart, and despite this prior contract wanted to move forward with the fertilization process, then usually courts would say, well, you have a contract. You must respect it. So either way, I mean, the application of contract law led to similar results, irrespective of the fact what was the actual content of the contract. Again, this is my understanding of the cases. I'm happy also to hear about other analysis, but this is my understanding. And we can see this starting from the first well-known U.S. case that I already mentioned, very well-known in this area, Davis v. Davis, from 1992, so from a relatively very early stage of the development of this area of law. We have here two former partners, Mary Sue Davis and Junior Davis. They are starting IVF treatment. They have frozen embryos. Then they depart. By the way, originally, Mary Sue wanted to use the 7 embryos for future attempts to become pregnant. But eventually, and I mention it because I think it may be relevant to the analysis of the reliance model, eventually she wanted to donate them, not to use them for her own, to the fulfillment of her own interest in becoming a mother. And I think that as a background fact, this is important to mention. Anyway, there was a contract about the ability to move forward with the process, but the court says, well, this is an unenforceable contract. On the other hand, if we move to the next case in U.S. case law, Cass v. Cass, decided 6 years by another court, there the contract provided for not moving forward with the process in case the two partners split, and then the court says, well, you have a contract, why not respect it? So, and I could follow with you also other cases that have these remarkable names such as AZ v. BZ and, JB v. MB and so on and so forth, but they all lead to similar results, and I want to make the best use of my time, and therefore I will not get into the details of these cases, but I'll just say that there are plenty of cases of this type, and they all, almost, I will soon mention the exceptional ones, but most of them lead to the result, because either the contract is unenforceable or else it should be respected. Either way, it leads to the same result. So as we can see, so far, the use of the contractual model leads to the priority of the will of the parties who don't want to proceed with the IVF process, no matter what the content of the contract was. Of course, theoretically, the contractual model can lead also to another result if courts were deciding that there is a contract to proceed and we enforce it. But this was not the typical choice of the courts. Now, in contrast, I will try to show other ways of thinking about the issue, because maybe I was maybe talking for too long about the contractual model, and I want to now to present the other possibilities. And I want to present on the side of the contractual model what I call the reliance model, and use the experience of my own country of Israel, mentioning a very well-known case in the Israeli system known as the Nachmani v. Nachmani case, also decided in the 90s after the Davis v. Davis case. It was also already known to the Israeli court, and also even mentioned, because, by the way, Israeli courts in general and the Israeli Supreme Court in particular have a very benevolent and open attitude to the use of comparative law. I'm mentioning it because, as I understand, there are other views as well. So this was something that was on the table. It was well known. Another interesting fact to mention about Nachmani, that it was decided twice. In the Israeli system, there is a special procedure that allows the court to re-decide the case in an enlarged panel if the original decision raised new important questions for the legal system. Maybe it's important to mention that we are 15 justices on the Israeli Supreme Court, and not all cases are decided by all the justices. In fact, none are accepted by all the justices. We usually, because we also serve as an appeal court, so usually the panels are panels of 3, but the court has this special capacity either to decide that this case is important enough to hear it originally in a broader panel, or if it was decided by a small panel, to rehear it in an enlarged panel if it justifies this, in the sense that it raises important new questions. You can think about it maybe using the experience of the European Court, where a grand chamber can hear a case after it was decided. So the Nachmani affair had 2 rounds. In the first round, it was heard by a 5-justices panel, and in that first original decision, the Israeli court followed to a great extent the American view and decided against, maybe I'll just tell you in a word or two the facts of the case, which are important here. Ruti and Danny Nachmani were a married couple. Ruti had cancer, and therefore she didn't have a womb, and they decided in order to make it possible for them to have children, to move forward with IVF procedures, also imagining the possibility of using surrogacy, because she could not carry the pregnancy herself. By the way, at the time, they thought of moving forward with the surrogacy in the US, because at the time, surrogacy was still illegal in Israel. Now it is illegal. So you see how the horizontal and the vertical arenas sometimes come together. Anyway, I'll try to be brief and concentrate only on the relevant facts, and say that after a while, Danny got tired. He left the home, had another, partner. He had children with her, and he decided that he's not interested in moving forward with the process. For Ruti, his ex-wife, it was very important because for her, and this is relevant, it was the last chance for biological parenthood. For in this, so we can say, and I'm already using the terminology that I mentioned, she relied to a great extent on the process. In the first round, the Israeli Supreme Court applied the concept quite similar to the ones used by American courts, since I don't have a lot of time, so I'll not get into the details, but standard approach, this is an unenforceable contract, etc., and therefore Ruti loses. Then the court decides to use its special jurisdiction power to rehear a case in a large panel. This time the decision was given by an 11 justices panel, and majority and minority roles changed, because the new majority of 7 out of 11, so all the majority justices left, became the minority justices, and all those who entered the proceedings decided the other way. But what is the ruling concept? What is the ruling concept? What is the legal idea or method? To some extent, it's hard to know, because most of the justices use the very broad concept of justice. They say justice matters here, and in the circumstance of the case, justice leads to the prioritization of Ruti. So they don't necessarily use the concept of reliance, but I would suggest to you to read the case as a case of reliance, because it's not the ordinary, case of a person who wants to proceed with donating the frozen embryos, giving them to research, whatever. It's a woman. It can also be a man in different circumstances, because, as I said, this is a distinction in comparison to abortion law. It's not necessarily about the mother. It can be also a man who lost his capability to bring children because of cancer, etc. We can also imagine of reversing the roles. Anyway, for her, it's the last chance for biological parenthood, and therefore I think it's a case of reliance. Again, with all the humility in reading relatively new US cases, as I understand, there are some newer cases in the US that can be thought of as using the same idea of reliance, although not necessarily using this terminology. And I'm referring here to Reber v. Rice and Zafransky v. Danson. I hope that I pronounce the names properly. These are cases from 2012 and 2015, respectively. In both of these decisions, the background cases were cases of couples who started with IVF procedures because the woman in both cases had cancer. So they started the process because if they didn't start it this way, they knew that they will not be able to bring children together, and probably for the woman it will not be possible at all. In both cases, different courts in the US decided for the woman. To some extent, I don't have the time to get into the details. I think that even in an implied manner, it presents a very similar direction to the direction of the Nachmani court. And if I understand right, again, I hope that I'm accurate, that in the Zafransky case, the US Supreme Court did not give certiorari. So it's a state court, but it's a state court decision, but still, I think it's interesting. By the way, the consideration of reliance is somewhere in the background, also in other cases. For example, the Irish case of Roche v. Roche, which concerned partners who had children together, and the woman wanted to move forward with the fertilization process to have more children with her ex-husband. So the Supreme Court of Ireland says, all all the circumstances would have to be considered carefully. If a party had no children and had no other opportunity of having a child, that would be a relevant factor for consideration. I think that in this way, the Irish court also presents a very similar argumentation, although this is a case where the woman did not prevail. Well, she had children, the background factors were different. I see that I'm running out of time, so I'll just say very briefly a few things about the role of legislation. As I said, what was interesting, I think, in all this judicial experimentation is that it was conducted without any guidance coming from the legislature. And this also, I think, brings very interesting questions about, responsibility of legislatures to deal with new social challenges, or maybe leave them to the court and then complain about what the courts are doing. But this is another thing. Anyway, in the UK, there was legislation in place, Human Fertilization and Embryology Act from 1990. And this English legislation stated that in case of IVF treatment, any party at any time can change his or her mind before the implementation of the fertilization eggs in the woman's uterus. This means that the UK legislation does not give a good enough answer, I believe, to the problems of reliance, where there are already frozen embryos and it is the last chance for one of the parties, because according to the legislation, even in such circumstances of irreversible consequences, still the other party can change his or her mind before the completion of the process in the woman's uterus, or sometimes the surrogate mother's uterus. And these were the background facts of the well-known UK case of the Evans case that eventually also went to the European Court of Human Rights. And I can tell you that since this was the view of the legislation, and without getting into all the details, Mrs. Evans lost the case, despite the fact that it was her last chance for biological parenthood, because this was the view of the legislature. By the way, this is also the view of expressing Canadian legislation, but this is not necessarily the case. In Italy, it's not like that. So some other systems, I will not review here, laws from all over the world, say that sometimes that maybe the proper point of changing one's mind is before the creation of the frozen embryos, because this is a point of no return, biologically speaking. How much more time I have, or I don't have time at all, maybe?
You have another minute.
Okay. So, as you can see, we are still in the process of, thinking about these issues. In the last minute that I have, I'll mention one case I was involved in, maybe just to bring some things together. In 2012, we had a case that is known in Israel as the sperm bank case, because otherwise it's like Roe v. Not a name that you will remember. This case was a case of a woman who used a sperm donation in order to bring to the world. She was an individual. A woman without a single mother, without a partner, and she decided to use sperm from a sperm bank and brought to the world a wonderful child. And she was so happy with that child, so she wanted to move forward and have another child by the same genetic father. She applied to the sperm bank and wanted to have more sperm by the same man. And then she got the answer that that man announced or gave a notification to the bank that he would ask them not to use his sperm donation in the future because he got married and now he feels differently about having children in the world. So maybe he takes full responsibility for, past actions, but he asked them cordially not to use his sperm in the future. The sperm bank wanted to respect his wish, And the woman was not happy with that because she wanted to have a sibling to her child that would be a complete genetic sibling. And she brought the case to the court, and we had to decide who should we prefer. And we decided for the man. And I think that, I mean, I cannot get here for all the details, but I think, and I was on the panel, that the consideration of reliance is very important here, because for her, she could have other opportunities to move forward with biological parenthood. She was not denied of parenthood. I mean, of course, she was influenced, but only to the extent that she will have 2 children not from the same father. I mean, this is not such an exceptional situation, and there are many happy families of this sort. So I think that in the background, we also see, at least from my perspective, the importance of reliance, and I invite you all to follow on the developments in this area. Thank you.
Thank you. We're out of time, but you'll be around.
Yes, I'll be around.
That's really wonderful. Thank you. That was so fascinating.